Isang napakagandang umaga po sa lahat ng nagre-review for the upcoming Criminology Licensure Examination. Sa lahat ng Criminology students sa Luzon, sa Visayas at sa Mindanao. Welcome po sa pangalawang episode, pangalawang discussion natin sa Human Rights Education, isang bagong subject under the new curriculum. Sa unang episode, we focused on the overview of human rights. We also discussed about the classification, including the organizations and the international laws that are in place relative to human rights. In the first episode, nag-discuss din tayo tungkol sa Republic Act 9851. Okay? Ang 9851, which was enacted by the Philippine government that will respond to the call on various conventions relative to the observance of the international humanitarian law. Na-discuss din natin sa first episode ang rights of the prisoners of war. Okay, ang mga karapatang pantao sa mga captives of war. So to continue, ang pinakamit, the core element or the core topics in the subject human rights education would be on the Bill of Rights as mandated under Article 3. Okay? Article 3 of the 1987 Constitution. So basically, in this episode, discuss po natin yung MIT, yung Bill of Rights. Pangalawa, yung rights of the children, rights of the women, rights of the ethnic groups. At the same time, bigyan po natin ng pansin ang function on the Philippine Commission on Human Rights. Para lubos nating maintindihan, define muna natin kung ano ang Bill of Rights under Article 3 of the 1987 Constitution. Ang Bill of Rights is a declaration and enumeration of a person's rights and privileges, which the Constitution is designated to protect against violation of the government or by individual or groups of individuals. It is a charter of liberties for the individual and a limitation upon the power of the state. So ano po ba ang ibig sabihin ng Bill of Rights? Ang Bill of Rights po is a declaration. Deklarasyon po yan. Deklarasyon po na nag-enumerate, okay, nag-enumerate sa karapatang pantao. Pati na ang mga privileges. Nakalagay po dyan. Nakalagay po yan sa 1987 Constitution. Ang Bill of Rights ay tinatawag na Charter of Liberties. Charter of Liberties in a sense that by exercising the Bill of Rights, you are exercising your freedom. Kasi sabi ko sa first episode, hindi po tayo robot. Human beings po tayo. So human beings are entwined, are privileged to have human rights. So without human rights, we do not have freedom. Kaya tinatawag yang Charter of Liberties. Now, ang human rights is also one of the bases why we have a limitation of the power of the state. Dapat po ang government natin will have to observe in these limitations. The limitations are embodied on what we call as the human rights under Article 3 of our Constitution. Take note, cadets, 22 Bill of Rights or 22 rights po ang meron tayo under Article 3. So pagkalahatan, sa lahat na po, if we sum it up, mayroon po tayong 22 na mga rights that are articulated under Article 3 of our Philippine Constitution. Simulan po natin sa Section 1. Okay? Sa Section 1 of Article 3, Bill of Rights, 1987 Constitution. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the law. For us to understand what is Section 1, let us ask the question, what is due process? Ano po bang ibig sabihin ng due process? When can we say that a due process was observed by the government? There are two aspects that we can say that due process has been observed. Number one is that under the authority of the law that is valid under the Constitution itself. So meaning, if the performance of a legal act is under the law, is aligned with the law, and is valid under the 1987 Constitution, then you can say that such legal act is part of what we call as due process. Number two, after compliance with fair and reasonable methods of procedure required by the law. Ang procedure po natin is that everyone is presumed innocent unless proven guilty by a competent court. It does not say that once a person has been suspected of using drugs, it does not say that you have to kill him, that you have to shoot him. Because by shooting the individual who has been suspected of using drugs, you are violating his right to due process. Kasi ang due process po requires that there are steps, legal steps to be followed. May mga steps po yan. Hindi pwedeng patayan na lang diretso. Hindi pwedeng lagay mo diretso sa jail and penal institution. Kasi may step-to-step, step-by-step process po yan. So maging due process po yan if number one, naka-reflect po yan sa batas natin, nakalagay dyan, and is valid in our Constitution. At the same time, nag-comply ka with the reasonable step-by-step method or procedure. So ano bang procedure? Instead of killing, procedure is you file a case and the trial will begin. That's the procedure. It does not say that you kill somebody. Killing somebody who has been suspected of using drugs is never articulated in our Constitution. So if nangyari dyan, you kill somebody, you shoot somebody suspected of using drugs, you are violating his right to due process. Sa Section 1 din, nakalagay dyan ang tatlong deprivations. Ano ba ibig sabihin ng deprivation? Sir, ibig sabihin ng deprivation, kinuha mo. You eliminate something. You take away something from a person. Ang deprivation po sa Section 1, tatlo lang po. Deprivation of life, deprivation of liberty, and deprivation of property. Ano ba ibig sabihin ng deprivation of life? Meaning, yung buhay ng isang tao kinuha mo, loss of any of the various physical and mental attributes which man must have to live as a human being. Deprivation of life, yan. Pinatay mo ang isang tao. That's deprivation of life. You traumatize somebody that caused him to be delusional. That's deprivation of life. Pangalawa, deprivation of liberty. Ang liberty po, yung kalayaan natin, yung freedom natin. You imprison somebody, you put him in a Bartolina without probable cause, without justifiable cause. That is a violation under Section 1. Because basically that is a deprivation of liberty. You restrict an individual to worship his religion. That is still a deprivation of liberty because everyone has the freedom to choose a religion and to worship based on his belief. Deprivation of property, kinuha mo. It's either you take it away from the person or you destroy the property of the individual. For example, you go to a squatter's area and you proclaim that you own the property and you start destroying house to house. O that is a deprivation of property. So, the deprivation of life, the deprivation of liberty and property should undergo what we call as due process. Dapat may due process po yan. Hindi po pwedeng you just imprison somebody without due process. Hindi po pwedeng you just take away the property of a person without due process. Ano po ba ang ibig sabihin ng due process? Ang due process again ay ang pag-follow ng reasonable steps, yung legal methods natin. But again, the reasonable methods and the reasonable procedures should be within the tenets of the law. Nandyan po under the authority of the law that is valid also under the Constitution. Diyan po mangyayari ang deprivations kung may due process po. Okay? So again, importante po ang due process before you can deprive anybody of life, liberty, and property. Section 1 din nakalagay in the last statement that all persons should never be denied the equal protection of the law. Okay? Nobody should be denied with the equal protection of the law. So I ask the question, what is the meaning of equal protection of law? Para maintindihan po natin, para pag nakaabot tayo sa board examination, if this all will come out in the board examination, at least everything is clarified na. So ano ba ibig sabihin ng equal protection of the law? Basic po, napaka-basic po. Ang equal protection of the law entails that the law should apply to everybody. Okay? Should apply to everybody irrespective of any circumstances or background or condition you have in life. Whether you are rich or you are poor, educated or not educated, professional or not professional, male or female, fat or thin, whatever circumstances that you have in life, everyone has the right to be equally protected under the law. Kasi ang nangyari ngayon in our society, I'm sorry to say this, especially police checkpoint. Ang nangyayari kasi, usually ang motorcycle lang ang naging most bullied vehicle in the Philippines. Why? During checkpoint, ang nangyayari, Cardo Dalisay individuals will only flag down or will only instruct drivers of motorcycles to pull over. Pull over. But if in case somebody is a wealthy individual driving a four-wheeled car, usually ang nangyayari, they just let them pass by. But most of the time, I'm not saying I am not saying this applies to the entire nation in the implementation of the checkpoint. But usually, based on observation, ito po ang nangyayari sa community natin. Dapat kasi, there should be an equal protection of the law. Kahit pobre ka, okay? Kahit pobre ka, the moment you go to the police station, dapat the assistance should be prompt. Okay? It should be prompt even if your standing is in life is just at a lower level. Why? Because Section 1 tells us that every person, everyone, okay, has the right to be equally protected under the law. Pangalawang karapatan po ay nakalagay sa Section 2, okay, of the 1987 Constitution, Article 3. The right of the people to be secure in their persons' houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. Ibig sabihin po, lahat ng mga Pinoy may karapatan po tayo to be secure in our houses, okay, in our persons, even our papers and effects against unreasonable searches. And no search warrant or warrant of arrest shall be issued except upon a probable cause. Okay? We'll discuss later on what is a probable cause. To be determined personally by the judge after the examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. So, ang ibig sabihin po sa Section 2, may karapatan po tayo to be secured, okay, in our own persons, houses, papers, and effects against mga searches na yan or warrant of arrest. But then again, ang karapatan na ito under Section 2 is not absolute. Okay? It's not absolute right, but rather it is a limited right. Why? Because in Section 2, it has been stated that anybody can be subject to search if there is a warrant, if there is a search warrant, and can be subjected to arrest if there is a warrant of arrest, provided that according to this section, there should be a probable that exists. Okay? A probable that exists. Sino ang mag-determine sa probable cause? Ang judge upon the examination under oath or affirmation of the complainant, including the witnesses and the evidences he produced. Para mas lalo nating maintindihan ang Section 2, we will go back to the scope. Okay, the scope of protection of Section 2. Tatlo lang po yan. Persons, houses, papers, and effect. We will start with person. Ang persons po that are protected under Section 2 do not only include Filipino citizens. Okay? But this also includes aliens. Ano ba yung aliens? Ito ba yung mga UFO from other planets? Hindi po. Ang aliens refers to foreigners. So if an American guy will reside in the Philippines under the principle of generality and territoriality, they are under our protection, under the protection of our laws of the Philippines. So again, ang persons do not include only Filipino citizens but also foreigners residing in our country. Ang houses po naman is not limited to our personal abode or our personal dwelling. Ang houses includes yung garage, yung warehouse, yung shop, yung store, even safety deposit vault. Naka-include na po yan sa definition ng houses. Ang papers and effects will also include sealed letters and packages in the mail. It can be opened and can be examined in the pursuance of a search warrant. So, ang nakalagay sa Section 2, lahat po tayo may karapatan against unreasonable arrest or unreasonable searches. Pero, ang sabi ko kanina, this karapatan, this right is not absolute. Why? Because this is derogable. It is limited. Limited in the sense that this right can be taken away in the presence of what we call as a probable cause, which will be determined by the judge. So if there is a probable cause, a warrant of arrest or a search warrant can be issued against you and you loses your right against searches and arrest. So yan po ang mangyayari. Now, tingnan po natin kung ano ang probable cause. This is just a review sa lahat ng under sa old and new curriculum. We mentioned this so many times in the major subjects. Probable cause, and probable. Even in criminal law, even in CGS, criminal justice system, we always keep on mentioning what is a probable cause. But review lang natin. Ang probable cause refers to facts and circumstances as are sufficient to engender a well-founded belief that a crime has been committed and that the respondent is probably guilty thereof and should be held for trial. So if we will understand this piece by piece, ang ibig sabihin ng probable cause, ito po yung mga ebidensya natin. Okay? Ebidensya that will make a prudent man believe that a crime has been committed and the person might be guilty thereof. For example, Pedro opened your drawer and took up the 5,000 pesos. And all of these happenings was recorded in a CCTV footage. So ang CCTV footage can be an evidence that will prove or that will tell you that Juan or this guy was the person who stole the money. So you now have the so-called probable cause. Walang probable cause po pag you just go to a park and arrest somebody just without justifiable reason. Wala po yung probable cause. Or somebody told you that Maria took your money and you go to Maria and arrested him. That is not a probable cause, because the probable cause will have to be based on circumstantial evidences and tangible evidences that will prove that this person committed the act and that he might be probably guilty thereof. Yan po ang ibig sabihin ng probable cause. You're a police officer and somebody told you that Pedro was into the illicit or illegal drug business. And after that, when you receive after you receive the statement, you proceed on conducting a surveillance, an intelligence activity on Pedro. And lo and behold, nakikita mo in your plain eyes that Pedro was in fact into the illegal drug business. So you now have your evidences on hand plus your deposition. We say deposition, the written testimony of the witness that Pedro was into illicit drugs. So if you will go to the court would say that there is a probable cause. Okay, there is a probable cause in order to arrest or in order to issue a search warrant against Pedro, because you have the facts and circumstances that will make a person believe that this guy committed a crime and that he might be guilty thereof. Pero pag ang nangyari would be on the other side, would be opposite, na you just receive a chismis from somebody. You receive a chismis that Pedro is into drugs and you proceed to the crime scene directly and proceed and arrest him directly. Again, wala pong probable cause in that situation. So, you are violating basically the right. Pero pag may evidences ka, may deposition ka, you conducted surveillance and intelligence activities against Pedro and you collected these evidences that would prove that Pedro committed the crime and he might be guilty thereof, then in that case, nag-exist po dyan ang tinatawag nating probable cause. Okay? So sa section 2, as I have said, di po yan absolute right. Okay? Di po yan absolute right. Ang tanong ngayon, sino ang mag-issue sa search warrant at warrant of arrest? Who is authorized to issue the warrant of arrest and the search warrant? Okay? Who is authorized? The person that is only authorized to issue the warrant would be the judge. The judge lang po, ang huwis lang po ang pwede na mag-issue. Pangalawang tanong, ano ang basihan sa pag-issue? Again, as I have told you a while ago, the basis for the issuance of the warrant of arrest and the search warrant will be the probable cause. Pangatlong tanong, ano ba yung probable cause? Ang probable cause would refer to evidences, the facts and circumstances that will help the person, a prudent man, to believe that a crime has been committed and that guy might be guilty thereof. Okay? So napaka-basic po, cadets, ang differences between warrant of arrest and search warrant. Ang warrant of arrest is an order signed by the judge directed to a police officer commanding him to arrest the person specified therein. Okay? Specified therein. Commanding him to arrest. Tawag po dyan, warrant of arrest. Question, sir. Ang nakalagay sa rule of court, sir, ang validity ng warrant of arrest is 10 days. Na-discuss ko na po to sa other episodes. Okay? Sa mga other subjects. Ang 10 days po dyan, hindi po yan lifespan ng warrant of arrest. Because the lifespan of the warrant of arrest is forever. Unless it is effected, quashed, or has been lifted. Pero pag hindi yan lifted, hindi yan effected, hindi yan na-quashed by the regional or by the trial court, maging effective po yan, maging standing po yan. Wala po yang invalidity. Alright? There is no lifespan. Okay? Validity of the lifespan. Ang 10 days po na nakalagay sa rule of court, ay ibig sabihin po dyan, those are the number of days for the police officer to file his report to the issuing court should he fail to effect the warrant of arrest. Ano ang 10 days? Yan po ang reglementary period na mag-file ka ng report sa issuing court ang nag-issue ng warrant of arrest. Number 2, search warrant. Ano ang search warrant? Same lang ang definition ng warrant of arrest. Only that, in a search warrant, instead of arrest, ang nangyari, to search. Sino ang nag-issue? Judged. Ano ang nangyari? He ordered the peace officer or the police officer to search a particular property and bring it before the court. Okay? Bring it before the courts. That's the difference between search warrant and warrant of arrest. But again, take note, under Section 2, a search warrant and warrant of arrest, which will only be issued by the judge, shall only be issued once there is a probable cause. Now, another reason bakit ang Section 2, the second right, is derogable or limited in a sense that anybody can be arrested without a warrant based on the grounds of in flagrante delicto, hot pursuit, and escape prisoner. Tatlo po yan. Okay? Tatlo po. Derogable po ang Section 2. Very limited right. Kasi anybody under these three circumstances can be arrested po without a warrant. Ang pagkasabi sa Section 2, pwede kang ma-arrest, pwede kang ma-search pag may warrant. Pero ang sabi ko, again, limited yan na right. Kasi anybody can be arrested. Pwede ka pong ma-arrest pag nabilong ka in any of the three circumstances. Una, a police officer can arrest you without a warrant when in his presence the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Ang tawag po dito, take note cadets, in flagrante delicto arrest. So pag ang board examination magtanong sa iyo, ano bang ibig sabihin ng in flagrante delicto arrest? So dapat ang answer mo is, when in the presence of the police officer, the person to be arrested has committed, actually committing, or is attempting to commit an offense. Yan po ang ibig sabihin ng in flagrante delicto arrest. Pero, ilagay po natin sa kukote natin, kailangang ma-meet ang two requirements before we execute the in flagrante delicto arrest. So, dapat ikaw na mga maging police officer, dapat you have to be mindful with these two requirements. Una, the person to be arrested must execute an overt act. Ang tanong ngayon, sir, ano ba ibig sabihin ng overt act? Ang overt act, ibig sabihin, you perform it externally. You perform it externally. Kasi, if you only perform the act internally, let's say you have this hatred against Pedro and you murder him. You murder Pedro 1,000 times in your mind. In your mind only. You wanted to hurt Pedro in your mind only. That is not an overt act, but rather a covert act. An act is considered as overt when you perform externally the act. Okay? You perform externally the act. So, in number 1 requirement, the person should perform an overt act indicating that he has committed a crime or is actually committing or is about to commit the crime. Number 2, the act should be done in the presence or within the view of the arresting officer. Dapat nandyan ka. Dapat you are present in the area. Because if you are not present on the area, problema tayo. For example, somebody just give you a chismis and that somebody said, Sir, Pedro stole my 5,000 pesos. And you go and proceed to the area and you arrested Pedro under the virtue of in flagrante delicto arrest. That cannot be justifiable under the court of law. Why? Because you were not there. That is just a cockpit of chismes. That is just a hearsay according to the law. So, di pa pwede. Dapat, he executed the overt act. Number 2, dapat nangyari ang overt act in your present. And dapat, ang person has committed, or number 2, is actually committing, or number 3, is attempting to commit a crime. Now, I put in the lowest portion. I state in here that it is not sufficient that the suspect exhibits unusual or strange acts or simply appears suspicious. That is not a sufficient ground. For example, while doing patrol, you as the police officer, you saw Pedro staring on a jewelry shop. Or staring on a jewelry shop. And when you observed him, Pedro was there for about 3 hours, just staring on a jewelry shop. Just staring on a jewelry shop. Staring on a jewelry shop for 3 hours is very suspicious. But even though it's very suspicious, that is not a ground for you. That single circumstances is not a ground for you to execute an arrest on Pedro. Why? Because mere suspicion is not a ground for in flagrante delicto arrest. Question: in flagrante delicto arrest, do you need a warrant? The answer is no. You do not need to procure a warrant because of the urgency. It would be very impractical, cadets, pag may nangyari na krimen in front of you and you go to the judge and ask for a warrant. Wala na po. Pagbalik mo, wala na. Wala na ang krimen kasi because of the lapse of time. So dapat you execute immediately the warrantless arrest. Second ground for arrest without a warrant. When an offense has just been committed and he has a probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. Ang tawag po dito, hot pursuit arrest. Yung una is in flagrante delicto arrest. Yung pangalawa is hot pursuit arrest. Now, ang ibig sabihin ng has just been committed, para maintindihan, this connotes immediacy. Now, ang measurement of immediacy is between the time the offense was committed and the time the arrest was made. Diyan po ang measurement ng immediacy. Take note, cadets, na ang hot pursuit arrest, to be valid, dapat you execute it within the day. I repeat, for the hot pursuit to be valid, dapat you execute it within the day. Now, ang difference po ng in flagrante delicto sa hot pursuit is that in flagrante delicto, andyan ka sa crime scene. You saw what happened. But in hot pursuit, you are not there at the scene. Only that you receive evidences, you receive report justifiable for the execution of the hot pursuit arrest. You were not there. Somebody told you, Pedro shot Juan with a firearm. And there is a video that was shown to you. You can conduct hot pursuit arrest. But the hot pursuit should only be valid within the day. Sir, ang tanong, bakit? Anong mangyari, sir? Pag ang crime happened Monday, and you conducted hot pursuit and you arrested him Thursday, Ano mangyari, sir? Ang mangyari is that the arrest will not be considered as valid. Kasi it was not executed within the day. So, pag hindi mo na-arrest ang tao, ang perpetrator within the day, it should be done that in the next day, you procure a warrant of arrest. And when you saw that person on the next day, that's the time that you arrest him because you now have a warrant of arrest. Sir, here is the situation. The crime happened Monday. I did not procure a warrant of arrest. I saw the person, the same guy, Friday. I saw him Friday. Will it be justifiable for him to execute an arrest? The answer is no, it's not justifiable. It cannot be considered as valid. Why? Because you do not have a warrant of arrest. And the commission of the crime already lapsed within the day. Ang sabi po ng jurisprudence natin, ang sabi po ng batas natin, hot pursuit should be done within the day. This is something that you have to take note, cadets, if you are planning to be part of the Philippine National Police. Now, ang last one is yung taong prisoner. Ang prisoner dito can be, number 1, serving final judgment, number 2, temporarily confined, or number 3, a detainee. Ang mga tao na to that are confined inside the jail, if they escape from a penal establishment, you do not need to procure a warrant of arrest. All you have to do is to arrest them directly. Why? Because under the paragraph C of Section 5 of Rule 113, the police officer has the power to arrest an escaped prisoner. So aside from warrantless arrest, ang Section 2 na right of the person is limited again because of search without a warrant. Okay? So may mga grounds po tayo that anybody can be searched without the virtue of a warrant. If again, that somebody ay pasok po sa mga circumstances na mga ito. For example, number 1, warrantless search incidental to a lawful arrest. Ano bang ibig sabihin dito? When we say incidental po, meaning consequence lang po yan. Ano ang nag-una? Ang nag-una is lawful arrest. After the lawful arrest, you conducted a warrantless search. Ang tanong, is the warrantless search valid? The answer is yes, because the warrantless search is preceded by a lawful arrest. So, dapat ang nag-uuna is ang lawful arrest. Tapos, you conduct a warrantless search. And that warrantless search can be valid. For example, you execute a warrant of arrest against Pedro. After you execute the warrant of arrest of Pedro, you are successful. You handcuffed him. After you handcuffed him, you pat him in his clothing, and lo and behold, you recover a .45 caliber firearm. The question right now is the search valid? The answer is yes, it is valid. Why? Because the search that was conducted was consequential of the lawful arrest. So dapat ang nag-una is ang arrest, tapos you conducted a search that is warrantless, and that is valid. Pangalawa, search of evidence in plain view. Dito po tayo nagka-problema. Yung mga police officers natin, usually dito sila nagka-problema legally. Kasi yung I tell you, cadets, yung job of being a police officer is very sensitive. Pag nagkamali ka po, you are a law enforcer, so dapat you have to be well-versed with the law. Kasi pag nagkamali ka, being a police officer, I tell you, dalawa lang po ang mangyayari. Number 1, it's either you will be suspended or demoted, or number 2, you will be terminated because there is a case. You have been found guilty of if a crime you committed because of violation of this of the of these tenets of law. So dapat we have to be well versed. So dito po nagkamali usually, nagka-problema po tayo ang mga police officers natin. Search of evidence in plain view. Ang plain view po, ibig sabihin diyan, napakasimple lang po. Anything seen on plain sight. Meaning, plain sight po, yung visual lang natin, visual on things, not readily observable. Ibig sabihin ng readily observable, you do not have to scan, you do not have to lift, you do not have to throw things just to look for something. Meaning, kung ano ang nakikita mo, yan na. Yan ang plain view. Kung ano ang observable, yan ang pasok sa principle of plain view. Ang evidence na makikita mo dapat immediately apparent. Ano ibig sabihin ng immediately apparent? Meaning, nakikita mo agad. Nakikita mo agad. Because if you open the drawer, you saw the evidence there. Of course, the evidence you recovered is not apparent. When you say apparent, nakita mo na may firearms on top of the table. Apparent yan. When you conduct a checkpoint, you saw that the person was bearing with him a suspected sachet of methamphetamine hydrochloride. Apparent yan. Apparent. Because that is observable. Pero pag ang particular evidence is hidden ha, ibig sabihin, hindi yan apparent. Kasi naka-hide Naka-hide yung ebidensya. Pangalawa, the evidence was inadvertently discovered by the police who have the right to be where they are. Ano po ibig sabihin ng inadvertence? Nilagay ko na po dyan para maintindihan. Ang inadvertence, ibig sabihin, you as a police officer conducting the search has no knowledge that the evidence is present in that particular place during the execution of search. Wala ka pong kamuang-muang. You do not have the knowledge that the evidence is there. You just saw it. You just saw it, apparently. You just saw it on top of the table. Or you just saw it on the floor. That is what we call as inadvertence. Because if you knew in the first place that the evidence is already that the evidence is inside the drawer and you scan it, you took the evidence, that is a violation of the inadvertence rule. So dapat, ang plain view po, dapat ang ebidensya is makikita mo agad, observable po. Number 2, dapat inadvertently discovered, meaning aksidente lang po ang pagka-discovery. Yan po ang tinatawag natin na plain view. Okay? So, pwede bang i-confiscate? Pwede bang i-search without a warrant? Without a search warrant? The answer is yes. Why? Because napasok po yan sa circumstances on plain view doctrine. Ang pangatlo is search to a moving vehicle. Now, ang moving vehicle po, ang mangyarian is that if you are a police officer, usually there is a reduction of sight or of visual. Kasi yung vehicle is on transit Is on transit, especially if the vehicle is running 80 kilometers or 90 kilometers per hour. Of course, that will reduce your visual as a police officer. So, pag may suspicion ka po, that will lead to a probable cause. For example, nakita mo, running vehicle, an individual making another person as a hostage using a .45 or a high caliber firearm. You saw it in your plain eyes, but the vehicle is moving. Do you have the probable cause? The answer is mayroon na. You have the probable cause, and you can search the moving vehicle without a search warrant. Ang pang-apat is consented warrantless search. Again, dito po, this is another area. Okay? Another area po na nagka-problema ang mga police officers natin. Consented. Ano po ibig sabihin na consented? Ibig sabihin, yung tao na subject for arrest tells you, permits himself to be to be searched. This is a part or a gesture of or an act of relinquishing or abandoning the right against search. So, pag sabi ng police officer, I want to search you. And the guy said, okay sir, no problem. Or that is what we call as consented search. Pero, ikaw na police officer, in the consented search, dapat you have to observe the principles underlying consented search. Kasi ang tanong, is mere verbal consent enough to justify a consented search? Is mere verbal consent enough to justify a consented search? Ibig sabihin ba na pag ang tao nagsabi na, sir, okay sir, no problem sir, you can search me. Ibig sabihin ba that is already a good ground to justify a valid warrantless search? The answer is no. Why? Because we have to observe 1 to 9 as you can see on your screen. Number 1 is that in the consented search, dapat you have to consider ang age of the defendant. Ano ba ang age of the defendant? Meaning, pag ang tao ay minor, for example, 17 years old or 16 years old, the consent is not valid. Okay? The consent is not valid because he is still a minor. Or if the person you are about to search is a 10-year-old, the consent, again, is not valid because of the age of the defendant or the person. Pangalawa, try to consider the location, whether it is public or secluded location. Ano ba ibig sabihin na secluded? Secluded meaning hidden from view. Pag kinuha mo ang isang tao, you instruct him to be there at a very isolated area na walang makakita sa inyo. And you ask him, is it okay to search you? Even if the person will permit it, again, the search is invalid because in that case, the will or the volition of the person has been clouded because of intimidation and the fear on you as a police officer. So hindi po pwede, hindi magiging valid yan. So dapat it should be in a public place. Number 3, whether he objected to the search or passively looked on. A mere gestures like nodding the head of the person should not be a good gesture that will warrant for the warrantless search. Dapat there has to be an explanation on your part and a verbal response on the part of the individual. Number 4, dapat i-consider mo din ang education and intelligence of the defendant. Because ang education, usually ang nangyari po, mga cadets, pag ang mga kapatiran po natin sa bukid, pumunta ng town, tapos may police, ang mga tao na to, especially yung I'm sorry to say this, hindi naman lahat, yung may low education na nasa far-flung areas, medyo ma-intimidate sila. So, ang intimidation na yan will cloud the voluntariness on the part of the person. So, dapat i-consider mo din yan as a police officer. Number 5, the coercive police procedures. Okay? For example, yung police officer natin na medyo demanding, medyo bossy. Give me your license. Yung mga ganyan, di ba? Give me your OR of the motorcycle. I want it now. These are examples of a bossy, a very coercive nature of procedure. Di ba? Makita natin yan sa checkpoint. Di po yan pwede. Dapat we have to consider it. Because if you do that and the person is intimidated and you conducted a search and you found a .45 caliber firearm, the question is, can you use the .45 caliber firearm as an evidence against the person? Technically, no. Legally, no. Why? Because the search is invalid. And the evidence can be considered as a fruit of the poisonous tree. Number 6, defendants believe that no incriminating evidence will be found. Dapat consider mo din yan. The nature of police questioning, dapat you have to be polite. The environment in which the questioning took place and the possibly vulnerable subjective state of the person consenting. Okay? Pag ang tao is a special child, pag ang tao has a defect in mind, you subject him for the arrest, for the search, and he consented. The problem there is the search valid or invalid? In that case, taking a look on the vulnerability of the person, that can make the search invalid. So, dapat i-consider mo lahat to. Pag naging kardo dalisay ka na, naging police officer ka na, cadets, after the review, you pass the board examination, after taking a look on the discussions that we have right now, naging police ka. O, dapat you go back again to this discussion para at least when you go there at the field, you will be guided on what to do. Because an ignorant policeman is a futile, a mentally paralyzed law enforcer. You are not effective if you do not know the law. Because after all, a law enforcer should be well versed with every single law that we have in our country. Ang panglima na basis sa search without a warrant is custom search. If we will go to the airport or the seaport, yung mga baggage natin is subjected to an X-ray search. Nag-search po ang mga police officers natin, ang port authorities natin, ang Coast Guard natin. Sila nag-search. But the question is the search valid? The answer is yes. Because that is under paragraph D, section 2203 of RA 1937. No need to procure a search warrant in that case. Number 6, ito po. Stop and frisk. Ang tawag po nito is Terry searches po yan. Stop and frisk ha. Tawag dyan, Terry searches. Ang nangyayari po sa stop and frisk search, ang police officer, you flag or you stop. You instruct a person to stop. Okay? And then you interrogate him. After your interrogation, you pat him for weapons or contraband. Now, the grounds of suspicion are reasonable when it's based on actual facts strong to create the probable cause. Ang sabi ko kanina, mere suspicion should not be a ground for warrantless search or warrantless arrest. Mere suspicion. Pero sa stop and frisk or Terry searches, pag ang suspicion is reasonable, okay? Reasonable. Pwede po na mag-search ka without a warrant. Ang tanong po ngayon, kailan maging reasonable ang suspicion? Okay? Kailan naging reasonable ang suspicion? Maging reasonable ang suspicion if it includes more than one circumstances. More than one circumstances. That if you put together these circumstances, it will tell you that a criminal activity is being done. More than one circumstances. For example, first circumstance, you saw a suspicious person wearing a long jacket. Okay? It's a sunny day, but the person is wearing a long jacket. That's circumstance number 1. Circumstance number 2, you saw a tip of a metal suspected to be a muzzle of the firearm at the side waist of the person. That's circumstance number 2. Circumstance number 3, when you start to approach the person, when you are about to approach the person, that guy runs. Okay? Tumakbo po yung tao. 3 circumstances po. Now, is the suspicion reasonable for you to execute a warrantless search? The answer is yes. Because if you will put it together, one, wearing a long jacket, even if it is a sunny day. Two, you saw a metal, tipo a metal suspected to be a muzzle of the firearm at the sideways. Three, when you are about to approach him, when he look at you, he runs. Tumakbo po. If you will put it together, that will tell you that a criminal activity is about to be done or is being done. So in that case, that inference now is reasonable. That suspicion that you have now is reasonable. So therefore, you can now execute a warrantless search. Pero, remember, future police officers, dapat stop and frisk search should only be limited to outer clothing. Ano mangyayari? Ano ibig sabihin nito? Dapat you only tap him. Frisk search. When I say frisk search, you only tap him. Tap the outside clothing. Tap him for possible contrabands and weapon. Because if you instruct the person to strip, strip, ano ba strip? Meaning, you talk of the clothes of the individual, including the underwear. I'll tell you, your search is already invalid. Why? Because the stop and frisk search is only limited to outer clothing. By the way, cadets, ang stop and frisk or Terry searches, I almost forgot. In the stop and frisk or Terry searches, when you approach the person, a suspicious guy, dapat the first thing that you have to do is to introduce yourself, your authority, your rank, your name, whatsoever. You have to introduce him because that is also a requirement under the law. Now, let us go now to number 7, another ground for warrantless search. Exigent and emergency circumstances. Yung mga instantaneous na judgment or decisions like spontaneous situations. I put an examples on your screen, cadets. Hindi na po kailangan ng warrant yan. For example, rescuing an occupant on a burning house. After hearing a gunfire inside the house, you proceed. You go inside. Emergency aid to a person being injured inside the building. Response to a person who screams for help inside the establishment. You do not need all of this. These are exigent and emergency circumstances. It will be practical. Pag pumunta ka sa korte, you saw a gunfire, a repeated gunfire, tapos you go to the court to procure a search warrant. Wala na. Wala na. Huli na ang lahat pagpunta mo sa crime scene. So dapat, consider mo yan na exigent and emergency circumstance because the search can be valid under this principle. Ang last one po natin is ang warrantless search because of inspection of buildings and other premises for the enforcement of fire, sanitary, and building regulations. Hindi na po kailangan ng search warrant. For example, nag-apply ka ng building permit. Tapos pupunta sa iyo yung personal na BFP. Mag-search kung meron ka bang fire extinguisher, yung point of exit mo, at saka yung point of entrance. Basically, they will be doing search. So do they need a warrant? The answer is no. Because they belong to the principle of number 8, inspection of buildings and other premises for enforcement of fire, sanitary, and building regulations. So basically, yon po ang mga grounds, ang mga limitations under the right, the second right under Section 2 of the Bill of Rights of our Constitution. Let's go to the Section 3 of the Bill of Rights of the 1987 Constitution. Section 3 talks about privacy of communication and correspondence. So the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by the law. So, this is a right under the Bill of Rights of the Constitution that entails the government to observe the right of privacy of communication of all persons. So dapat po may privacy of communication po tayo. Hindi po pwedeng ang government will just interfere on our chat with our loved ones. For example, yung mga girlfriends natin. Di ba? Mag-I love you tayo. Mag-I love you tayo sa boyfriend natin. So there should be privacy of communication. Because it is a right and it is inviolable. Ibig sabihin ng inviolable, hindi po dapat yan ma-violate by the government. Pero, ang karapatan na po ito ay may limitation din. Okay? May limitation din ang ating privacy of communication. Pero, before we will talk about limitation, let us first explain or let us first understand what is right of privacy. Ang definition po ng right of privacy is the right to be left alone. That's the basic definition po dyan. Or to be free from undesired publicity without unwarranted interference by the public in matters with which the public is not necessarily concerned. Take note of the words not public, not necessarily concerned. When you take a bath, pag naliligo ka, of course, there is an expectation of your privacy. Why? Because the public do not need to be involved in the process of taking a bath. Am I correct? When you slumber or when you sleep inside your room, there is a consideration that the privacy should be endowed to you. Why? Because in the act of sleeping, the public is not involved. You get the point? That's privacy. Pero pag nag-TikTok ka, you are dancing with your sloppy dancing in TikTok while you are inside the public, that does not connote privacy. Bakit? Because you are in the public, basically. And the public is involved on your shenanigans of dancing there. So that does not connote privacy. But if you are inside your house, you are doing this kind of stuff, the public does not have to be concerned about it, then there is what we call as the privacy. Okay? On the part of the person. So again, ang section 3 po talks about privacy. Pero may limitation po again, as I have said a while ago. Although sabihin na natin, may karapatan tayo sa confidentiality ng ating communication between us, sa mga boyfriend niyo, sa mga girlfriend niyo. O diba, iba sa atin, maraming boyfriend, maraming girlfriend, tapos maraming account. Okay lang po yan, may karapatan kayo dyan in terms of communication. But if an individual will perpetuate a crime, tapos yung krimen is done by the assistance of technology, I tell you, pwede po ang korte will execute a warrant in order to interfere your line of communication. For example, may tinatawag po tayong warrant to intercept computer data or WICD. Ano ba ang WICD? Kadets ha? Baka lalabas sa board exam. Ano ang WICD? Ito po ang order coming from the court, signed by the judge. Okay? Of course, upon the application of the law enforcer, authorizing the police officers to carry out any of the following activities. Number 1, listening to your call or your communication. Recording your communication. Monitoring your communication. Or worse, surveillance of the content of communication. Eavesdropping or tapping. Ano ibig sabihin ng eavesdropping? We see eavesdropping or tapping devices. For example, yung suspect on the other room. You put a device there. A device that will absorb the audio in that room. And the audio will be transferred from that room to your device. And you on the other hand is listening to that device. So basically, yung right of communication mo has already been limited. But the question is there a violation? Mayroong violation yan pag ang interruption or interference of communication is done without a warrant. Pero pag may warrant po yan, for example, yung WICD, nakakuha yung police officer ng warrant na ito, tapos he intercepted on your line of communication, wala ka nang magawa. Why? Because there is now a court order. Ang tanong, absolute ba ang right of privacy of communication and correspondence? The answer is, hindi po. Limitado po yan. Pero, may karapatan ka sa mga ganyan. Ang problema lang is, there is a limitation. Pang-apat, no law shall be passed abridging the freedom of speech, of expression, or of the press, or of the right of the people peaceably to assemble and petition the government for redress of grievances. Ito po, sikat po ito sa Pilipinas because of abuse of freedom of expression. Ang freedom of expression po is our karapatan, our right to utter and publish freely whatever we please, we wanted to publish without restraint. Okay? However, the publication or the utterance, yung pagsasabi po natin ng ating expression, when we express for something, dapat it has to be in consonance with the law. Bakit it has to be consonance with the law? It has to be in consonance with the law simply because we have the so-called slander and libel. Yes, we have the freedom of expression, freedom of the press. Diba? Ang mga media natin sa Pilipinas, they are scrounging information. Ang nangyari kasi sa media natin sa Pilipinas is that they are after on who can get the information first. They're not after of the quality. I mean, not getting the correct facts of the case, but rather who will be the first person who will air it on television. That's the measurement of success in the media, and that's very awful based on my observation. Although we have the freedom of the press, freedom of expression, you can say anything you want, opinionated statements, that is okay, but you have to be very careful because this right is limited also. Napaka-limited po yan. May slander po tayo, may libel po tayo. Ano ba pagkaiba sa dalawa? Yung slander at libel, puro yan false statement. Ang pinagkaiba lang, yung slander is made orally, verbally. For example, sinabihan mo na yung babae dyan, yung neighbor mo, yung kapitbahay mo ay buntis. And that destroys his reputation. Slander po yan, kahit hindi totoo na buntis. Slander po. Pero, ang libel, although false statement, hindi po siya verbally, but rather written po. For example, you wrote something and you would say that the government is the executor of the extrajudicial killing. Or you will say that the President of the Philippines is the one who execute the killing of so and so and so. Even without facts or evidences. Pwede po that publication sa newspaper nyo, pwede kang magka-libel. Also, common po, because we have the anti-cybercrime law in the Philippines right now. Common po ang e-libel. Ano ang nangyayari sa e-libel or electronic libel? Ang nangyayari po is you publish something through social media. And that publication in the social media is about false statements of somebody. You would say, "Oy, si Marites ay nagnakaw ng 5 million." But in reality, it is not supported with evidences. Pwede po i-libel. Sir, ang tanong, what if somebody post in my Facebook account and somebody post in his Facebook account about false statement and I just shared it? Will I be liable for e-libel? The answer is no. Hindi po liable. So long na ang pag-share mo sa post is not added with your own statements. Okay? For example, you just share it, you just don't say anything about it. You just share it in your personal profile. Will there be a libel on your part? The answer is no. But, if you will share it, tapos naglagay ka ng statements dyan, na libelous statements, pwede po, pasok ka sa i-libel. Pangalawang tanong, Sir, what if I just put a heart reaction, an angry emoticon, or a crying emoticon on the libelous post? Will I be liable for e-libel? The answer is no. According to the jurisprudence of the Supreme Court, liking, reacting to the post is not part of e-libel. It will not fall part of e-libel unless, again, you put or you added a libelous statement. So again, ang freedom of expression po natin, hindi po yan absolute. When we say freedom of expression po, it is our right to freely utter and publish whatever we pleases to publish without restraint, so long as it should be in accordance with the law. Next, under Section 5, no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. Ibig sabihin po, may karapatan po tayo na mag-practice kung ano ang mga doctrines or belief natin sa ating relihiyon. Iglesia ni Cristo ka man, Seventh-day Adventist ka man, Catholic ka man, born again, whatever religious sect you belong to, may karapatan ka po to practice the doctrines that you have in your religious organization. The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. No religious test shall be required for the exercise of civil or political rights. Now, para maintindihan, we will define the two terms. Una, religious freedom. Tsaka yung pangalawa, yung religious test. Ano ba ibig sabihin ng religious test? Unahin natin ang religious freedom. Ang religious freedom po, ibig sabihin dyan sa Section 5, ang religious freedom is our right to worship God. Karapatan natin na magsamba sa Panginoon and to entertain such religious views as appeal to his individual conscience without interference or dictation by any person or power or civil or ecclesiastical. Hindi po pwede na magsabi ang government na, hoy, Tarpulano, you should be baptized in the Iglesia ni Cristo or Adventist or born-again religion. Hindi po pwede magsabi ang government na only Muslims and Catholics should be the two religions whom the Filipinos should select to. Hindi po pwede. Wala pong preference. Kasi protected by po yan sa Constitution under Section 5 of Article 3. So religious freedom, you have the liberty to worship God, to entertain religious belief and views that you have in your life. Now, ang pangalawa, yung religious test. Ano ba ibig sabihin ng religious test? Baka lalabas to sa board examination. Ano ba ang religious test, cadets? Hindi po to examination. Ang religious test is an act of demand to avow or repudiate of certain beliefs before the performance of any act. Ano ibig sabihin ng avowal or repudiation? Ibig sabihin yan, you surrender. You surrender your religious belief before a performance of any act. For example, sabihin na natin, pwede ka pong mag-run for barangay kapitan pag naging Muslim ka or pag naging Kristiyano ka. Hindi po pwede yan. Why? Because that policy avows or repudiate your religious belief. Hindi po pwedeng somebody will tell you to surrender, to make that religion as a requirement. Hindi po pwede yan. I put another example. Laws prescribing the religious qualification of public officials or employees, whether appointive or elective or of voters. Ikaw yung mayor sa municipality niyo. Tapos sabihin mo, bigyan kita ng GO or job order pag magpabaptize ka sa Catholic or pag magpabaptize ka sa Adventist. Hindi po pwede yan. Why? Because under again in Section 5, we have the right to religion. Sir, what if ang tao walang religion? Pwede ba? The answer is yes. Again, because we have the right to practice our own views. Alright? As a human being. So again, yan po ang ibig sabihin ng religious test. Now, sa number 6, section 6 po, it talks about liberty of abode. Okay? Liberty of abode and of changing the same within the limits prescribed by the law. Dalawa po ang nakalagay sa section 6. When we say abode, yung tahanan po natin. Okay? Yung residence po natin. Ang pangalawa po na nakalagay sa section 6, yung right to travel po. Okay? Right to travel, which should not be impaired. Now, ang liberty of abode and travel would refer to the right of a person to have his home in whatever place chosen by him and thereafter to change it at will. May karapatan po ako, although right now I'm living in the municipality of Shaton in Negros Oriental. Pwede po that upon my discretion, I will transfer to Dumaguete. And after a year, I will transfer to Luzon. And after a year, I will transfer to Mindanao. I have that right because that right is protected. That right is given to me under Section 6 of the Bill of Rights. So, pwede po, anywhere you want. But it should be in accordance with the law. Okay? It should be in accordance with the law. Now, ang pag-travel po natin, right to travel, we will go to any country we want to. We want to travel any local places we want to. Pwede po yan. Pero again, there are restrictions. There are limitations of right to travel and right to abode, right of abode. Okay? Because if you will read closely, Section 6, may clauses po dyan nakalagay. Except upon lawful order of the court. Isang clause po yan. Pangalawang clause, except in the interest of national security, public safety, or public health. We will discuss number 1. Except upon lawful order of the court. Yes, you have the right to abode. You can live wherever you want. But if you live in a place, basically, is not owned by you. Tapos, there is a court order. An order of demolition. Diba? Common po ito sa Manila. There is an order of demolition. You cannot say to the court, like, Hoy, Your Honor, I have my right of abode. My house should not be destroyed. In that case, that right can no longer be invoked. Why? In the sense that there is now a court order under the first clause. Pero pag walang court order, you can live anywhere you want to. Pero pag may court order, dyan tayo pwedeng may limitation. Pangalawa, interest of national security, public safety, or public health. We have the right to travel, right? We have the right to travel. You can go to any local tourist spots. Ang nangyari ngayon, during pandemic, a lot of people are traveling from one place to the other. Pero, the government, in the interest of public health, can actually restrict your right to travel. Pwede ang government would say, okay, you are at this IETF level, and in that level, you are not allowed to travel. You are subjected to curfew even during nighttime. Hindi po pwedeng you would say, I invoke my right to travel. No. Why? Because the national interest will prevail over your right to travel. We have to consider na may health crisis. May pandemya po. May COVID-19. So in that case, the government, in consideration with the national interest of public health, the government can restrict your can restrict your right to travel. Ito pong dalawang clauses na to are what we call as permissible interference. Ibig sabihin ng permissible interference, ang pag-intervene ng government na pwede, permissible, legal, naaayon sa Constitution. Okay? Permissible interference. Now, Number 7, or Section 7 of the Bill of Rights. The right of the people to information on matters of public concern shall be recognized. Okay? Ang nangyayari sa Section 7 is that all people have the right to information. For example, access to official records, to public documents, government transactions, decisions, government research, blah, blah, blah. All of this is our right, one of our rights to access on this information. Now, ano ba ang scope nito sa Section 7? Ang scope po nito, number 1, public records po ha, hindi po private. Public records po, ano ibig sabihin ng public records? Pag na-notarize yan, private document, naging na-notarize yan, naging public record yan. Yung mga transactions of the government, yung bidding, di ba? Mag-bidding sila pag may project, public records po yan. Ang number of population inside the community, you can get that from the government. Public records din po yan. Pero, grades of the students, ano po tawag dyan? Public or private? Grades. Hindi po pwedeng matawag yan na public record. My goodness. That is a private information. You cannot go to a university and you would say, oh, I want to find out if my classmate is having a passing grade in human education subject. You cannot say that because that is a private record. Ang public record na po ang scope po dito. Pangalawa, it is limited to citizens. But, if in case, ang alien po, ang foreigner, is included as one of the litigants, meaning, complainant siya, or naging defendant siya sa particular na kaso, pwede po siyang mag-grant ng access on a public record relative thereto. Pangatlo, its exercise is subject to limitations. May limitations po tayo. Bakit? May tinatawag po tayong disclosure of confidential information which is a violation of the law. For example, ang nangyari, ang Philippine National Police drafted a plan to counteract the possible terrorist attack in a particular city. And you go to the police station and you get the information and you divulge it in the public, that is not allowed. Kasi ang scope po na ito, ang right to information po, is also a derogable. It can be a limited right. But if in case you will only focus on public records like the bidding, the plans of the government, on the construction of the building, the taxes, the liquidation, the callable accounts, all of this that can be released to you as a citizen of the country. Now, ang Section 8 po, madali lang po yang intindihin. Ang Section 8 po ay tungkol sa right to form association. Okay? Right of the people to form association. Ano po ba yung ibig sabihin ng association? Yung groups po. For example, gumawa ka ng fraternity group. Ang tawag dyan is Pochida. O, diba? Sa Cebuano, ang ibig sabihin ng Pochida is Pulo Chinilas Dalagan. Yan po ang ibig sabihin dyan. Pochida. Pulo Chinilas Dalagan. You want to make that kind of organization. Would it be legal for you to do it? The answer is yes. Why? Because it is valid. So long as the Constitution and bylaws are in accordance with the law of the land. So if you want to form it, that organization, that is okay. Okay lang po yan. Gumawa ka ng unions, associations, societies, you can do it because that is your right. Pero, ang ilagay po sa mind natin, that in the right to form association, okay, in the right to form an association, the person who is a member thereto also has the right to renounce his membership. Okay? Take note of that. He also has the right to renounce. For example, I am a member of the Pochida, and I want to resign, or I want to go out from being a member from that organization. Would it be valid? The answer is yes, because that is included under your right under section 8. Okay, that's what we call as right to form association. Pero hindi po pwedeng you will coerce someone to join you. Hindi po pwedeng you will say, oh, everybody should join. If you will not join, you will fail in class. That is something that violates your right. Ang section 9 po is private property shall not be taken for public use without just compensation. Ito, napaka-common po ito sa Pilipinas ngayon. As you can observe, our government is into the program Build, Build, Build. And part of the Build, Build, Build is the road widening. Diba? Lumalaki po yung daanan natin. Nag-road widening po tayo. Now, as an ordinary citizen, we can question it based on Section 9. I mean, private property should be a private owned land. And it should not be taken by the government. Pero ang number 9 po, we have to consider the fact na the majority will prevail over the few. Yan po ang principle dito. Ang government po, or ang batas po natin ay naniniwala sa concept na Latin na salus populi suprema est lex. Salus populi suprema est lex. Ano po ibig sabihin dito? Ang ibig sabihin ng salus populi suprema est lex, a Latin words, the welfare of the people is the supreme law. The welfare of the people is the supreme law. Ang ginagamit na word po dyan is people. Not individual person. People po. So, pag ang lote, alright, pag ang lote or yung property mo will be used for the welfare of the general public or the general community, then you have to give it to the government. But there should be a just compensation. Mayroon po tayong compensation. Ang tawag po dyan, dapat just When you say just, it should meet the standards. Why? Because the government can actually take your property. Ano ba ibig sabihin ng taking? Ang taking does not only include physical seizure or appropriation. Pwede pong distraction. For example, demolition ng bahay mo. Part po yan ng taking. Okay? Part po yan ng taking. Kasi ang government po natin may tinatawag na police power. Ang police power po dito, hindi ibig sabihin na the power of the police. But in the Constitution, ang ibig sabihin ng police power po, in the Constitution po, ibig sabihin yan, ang power of the state to enact laws or regulation in relation to persons and property as may promote public health, morals, and public safety and the general welfare and convenience of the people. General welfare po ang nakalagay. Okay? General welfare of the people. So the government can do that. They can enact laws and regulation for the general welfare. Now, aside from the police power, may tinatawag tayong eminent domain. Ang eminent domain is the right or power of the state or of those to whom the power has been lawfully delegated, like DPWH, Nasa kanila po na-delegate yung power na to take property to public use upon paying for the owner a just compensation to be ascertained according to the law. So ano pong ibig sabihin nito? Ibig sabihin na if in case the government will pay you a just payment, okay? A fair payment. For example, you take a look on the market value. Tapos ang market value sa land is 2,000 per square meter. Tapos ang bibilihin ng government is only 10 square meter. You have to multiply 10 by 2,000. So the result would be a fair compensation because that is based on the market value. Okay? That is based on the market value. So again, hindi po pwedeng ang government will just take it away from you without just compensation. But the taking should be done for the benefit of the general public. Now, let's go to the limitation para maintindihan. Sa limitations, una, there should be an existence of public use. Hindi po pwedeng bilhin ng government and there is no purpose of the buying. You cannot just say, you're the government and you will just say, I will buy your land and I will just do nothing about it. Hindi po pwede yan. Dapat may purpose po. Dapat po, ang purpose dyan is for the general public, not for a single politician. For the general public po. Pangalawa, ang sinasabi ko a while ago, dapat may payment of just compensation during the taking of the property. That time, during the taking of the property, sino po ang mag-determine ng value? Of course, yung assessor, which will be, which also be determined by the court. Yung assessor will be the one to take a look at it, how many square meter, but the exact value will have to be determined by the court. Number 3, observance of due process of the law. Hindi ibig sabihin na may demolition order, you just demolish immediately. May due process po tayo. Bibigyan ng specific number of months. Specific number of years. Bibigyan ng relocation area. Yun po ang due process. You do not just destroy houses away. Okay, that's what we mean by section 9. So dapat na-observe din po yung tinatawag natin na due process. Cadets, we already consumed 1.5 hour of our discussion in this episode. Kailanganin pong we relax muna. Mag-relax muna tayo. Ang continuation po ng discussion, yung section 10 up to section 22 of the Bill of Rights. Pati na yung remaining topics po sa subject na ito. Lagay na po natin sa third episode para at least we can have time to relax. Kasi I believe on the concept na too much of something is bad. So we have to relax after this. After a couple of hours maybe, we go to episode 3 para ma-continue po natin yung discussion natin. Please bear with the discussion po kasi package na po ito. Lahat ng mga topics are comprehensively discussed po para magamit nyo sa upcoming board examination. I hope learning is an easy, a happy experience on your part. Gawin po natin. Although studying is a painful process, pero if in case we have the good intention to pass the board exam, dapat gawin po natin. So I hope you will go to episode 3 and learn also the topics that are discussed in there. Thank you so much. God bless you and stay safe.